like to thank everybody for coming. I'm Jim Gottstein with the Law Project for Psychiatric Rights. I'm talking about litigating to address the psychiatric drugging of poor children. The Law Project for Psychiatric Rights, PsychRights, is a public interest law firm whose mission is to mount a strategic litigation campaign against forced psychiatric drugging and electroshock around the country. And we've made the drugging of children a priority, children and youth. I'm not going to go a lot into the extent of drugging children, but just to kind of set the stage a little bit. I'm really just going to be talking about the legal aspects of it. But just some, basic statistics. I think that we have 1 in 10 boys on stimulants. More than 1% of youth under 18 are given neuroleptics. I don't call them antipsychotics. I consider that a marketing term. They don't really have antipsychotic properties for most people. They mainly make people so they're less disturbed, basically, the people around them. There's no long-term benefit, and the short-term benefit, in my view, is basically for the people around them, so that they basically control the children and they don't, they're not as difficult to manage. Although that tends to be a short-term solution, and over the long term, it gets worse. 1 in 40 are on antidepressants, and the antidepressants are causing basically a massive amount of children being diagnosed with bipolar disorder. So in the Prozac boys studies, 23% developed manic-like symptoms, 19% more produced drug-induced hostility. So the psychiatric bipolar rate soared from virtually none to 1995 to 800,000 by 2003. And then once these children get diagnosed with bipolar disorder, then they get put on the mood stabilizers. Well, the anti-seizure drugs misbranded as, quote, mood stabilizers. They're really anti-epileptic drugs. Or anticonvulsants, and the neuroleptics. They're even prescribing and administering neuroleptics to 6-month-old infants. When they're... Do you disagree, Grace?
No, I can't believe it. I believe you. I just can't believe it's happening.
Yeah, and it's a fussy child, right? He's crying all the time and stuff like that. And we used to have a different name for it. Colic. Yeah, and they used to give whiskey for it, right? I think that probably fucked up. Yeah, so it's causing great physical harm, and the child mental health disability rate has soared from essentially 0 in 1987 to 800,000 by 2011, from 1988 to 2011. Okay, so now I'm going to talk about legal stuff. I'm going to talk about 3 legal approaches. One is civil rights violations under 42 U.S.C. section 1983, which is a Civil War era civil rights law. Off-label prescribing constitutes Medicaid fraud, and FDA petitions to withdraw or revoke pediatric drug approvals. So,
what's U.S.C?
United States Code. So it's a statutory scheme. So basically, Section 1983 says that if any person under color of state law is the way it's usually under color of law. So in other words, if they're acting on using the authority of the government that deprives a person of any rights, basically under the Constitution or laws, are liable to the person whose rights are being violated, both for damages and for possible injunctive relief. And of course, as always, the judges are pretty immune, and so there is a kind of an exception, which is if they're actually violating a federal injunction, then the judges can be held accountable. Okay, so There was this really terrible case in the United States Supreme Court called the Cheney versus Winnebago County, where the state discharged a child, released a child to his abusive father, and the state knew that the father was abusive and was harmed. And the Supreme Court said, well, once the state releases the child, they don't have any responsibility. So this has been, very rightly considered a terrible case. But the Supreme Court did say that when the person is in custody, that the Constitution requires that basically that they have to provide basic human needs and keep the person safe. Okay. Now there was a there is a case basically in the Southern District of Texas, and the judge issued a decision in 2015 that involved children in foster care. And it wasn't about forced drugging, it was about the conditions of foster care. And the judge pretty much exhaustively went through all the cases and things, and he said that state custody of a child creates a special relationship that triggers substantive due process protections. Okay, basically that's what the Cheney says. And that foster children have a 14th Amendment substantive due process right to be free from an unreasonable risk of harm caused by the state. And the state has a duty to keep foster children free from an unreasonable risk of harm. And then you don't have to wait. I mean, it's an unreasonable risk of harm. You don't have to wait for the harm to occur to get relief under the statute. And it includes psychological as well as physical harm. Okay, so the idea is really simple. Just use the 42 U.S.C. Section 1983 to enforce this right against the drugging of children in foster care. And foster children are, I think, drugged about 4 times more than other poor children on Medicaid. And Medicaid children are drugged with, at least with neuroleptics, I think about 9 times more than the general population. So the foster children, I mean, God help children once they get in the foster care system. They're automatically given a mental health evaluation, which basically is directed at that they find what they're looking for, and children have they are put into foster care because they've been found to have been subjected to abuse or neglect. Now, sometimes that's not true, but mostly it is. And so a child or youth is going to be upset about that and will act out, right? And that's a normal reaction. And even no matter how bad it is in the home situation, it's also traumatic to be yanked out of their house, right? And that would cause them to act out. And then a lot of times these foster care placements are pretty horrific in themselves. I mean, it's not unusual for them to be abused, but they're also, I think, they tend not to be treated as family members. They're really profit centers in a lot of cases. And they know that it's just lots of, I mean, there's many foster home, parents that are good, but many are not. And they're just, and they know that they're not part of the family because the holy grail for foster children is to get adopted. And then once they get to a certain age, the chance of being adopted goes way down. So I mentioned that they were, profit centers, right? And so one of the ways, so that's simple in terms of the theory behind it. The children have the right to be free from unreasonable risk of harm. The drugs, are an unreasonable risk of harm, and therefore you can bring suits to stop the practice. So, but it takes a lot of resources to do that. And we haven't really had that. We'd really love to get some. Okay, so then the next approach is that most of the psychiatric drugs prescribed to children and youth is not allowed under the Medicaid statute. And you could call that Medicaid fraud. And so Medicaid reimbursement is for outpatient drugs is only allowed for what's called a medically accepted indication. So there's a medically accepted indication is defined as uses approved by the FDA or, quote, supported by any of 3 compendia with drug references that they call compendia. And those 2 combined are a medically accepted indication. But another way, probably an easier way for people to think about it, is that if it's not a use approved by the FDA, then that's an off-label use. Okay, so if it's an off-label use, then it's not allowed under Medicaid, to be paid for under Medicaid, unless it has, quote, support by one of these compendia. Okay, so if you think about it, the FDA approved it, found it safe and effective, and then Congress said, well, we're not going to say you can't ever prescribe, we're not ever going to pay for off-label, but we're only going to pay for it if there's some legitimate scientific evidence for its use. And so that makes a lot of sense, both for the safety of the populace and for, the government treasury, And the statute lists 3, but one of them quit publishing about 5 years ago, I think. Yeah, so the American Hospital Formulary Service, Drug Information, United States Pharmacopoeia, Drug Information, or its successor publications, that's the one that hasn't, that ceased publication of the Drug X Information System, which we basically just go by because it's the most comprehensive. The AHFS, it's like a couple pages of just mash stuff together and pretty hard to interpret. But DrugDex is very organized. It's also very expensive. It's about $7,000 a year to get a subscription to it, and virtually nobody knows about it. I mean, I was talking to someone who was a former medical director of a hospital, and he didn't know about it. Do you, Grace? Have you ever heard of it? It's they actually list every study for each drug. Okay, so this is what, and DrugDex has these ratings, and they have efficacy, strength of evidence, and strength of recommendations. Okay, so strength of recommendation is the one I go for. And so class 1, the given test or treatment has been proven to be useful and should be performed or administered. Okay, that's support, right? Okay, the given test or treatment is generally considered to be useful and is indicated in most cases. Well, I think you could say that there are some cases, right? If you're not in most cases, then it's not support. But we don't really argue about that. But class 2B is the treatment may be useful and is indicated in some, but not most cases. Okay, so we say that that's not support. Okay, or at the most, it can only be support if you get in the not most cases category, right? But anyway, even if you but we're not even arguing over this. We're even in the lawsuits that we've done, we don't even bother about that because there's so much that's down in class 3. The given test or treatment is not useful and should be avoided. Okay, that's not support. Okay, so we developed this medically accepted indications chart for pediatric use, and we have it coded. So the white background is it's medically accepted. Orange is it's cited but not supported. So for example, Ambien is class 3, but we say it's not supported. This is Ambien for insomnia, short-term treatment. Anafranil Depression, it's class 2B. Okay, so this isn't really necessarily great for everything, because look at this. Abilify is approved down to 10 years for bipolar 1 disorder, and including adjunctive therapy with Depakote, basically, lithium or Depakote. Bipolar 1 disorder, monotherapy, manic or mixed episodes. So both acute manic or mixed episodes, and schizophrenia down to 13 years. So that's not great. But we know that children are getting prescribed Seroquel for sleep, right? Well, that's not a medically accepted indication. All right, but so it may have recently changed, but for example, Geodon, at least used to, have no medically accepted indications at all for pediatric use. And so if you go to have a child that was prescribed Geodon, you don't even have to know about anything else. That's not a medically accepted indication. Okay, so if you have a child that was prescribed Abilify, for something besides these, then it's not a medically accepted indication. So normally what you need to do is you need to know what the diagnosis is and what the drug is. And if it's not white or orange on this chart, then it's not authorized to be reimbursed by Medicaid. Okay, so then we come into the False Claims Act, which is also known as whistleblower cases, or key tam, where you sue on behalf of the government for charity recovery. So this is another Civil War era statute that was enacted in order to address the rampant corruption during the Civil War. You had these munitions and contractors that were providing rifles that would blow up in the soldiers' hands and stuff. And so the idea is that people can sue on behalf of the government for false claims and share in the recovery, if any. Okay, so they're deputizing the citizenry to, basically watch, or give them incentive to, blow the whistle for basically fraud. The people bringing the suit are called relators, so it's like, Randy Kretschmer in Illinois, he actually did one of these cases, I can't remember, what's the relator's name?
Oh, geez, Jim.
All right, I put you on the spot.
You got me in the middle of another thought process, I'm sorry.
Anyway.
Was it Wells Fargo?
I'm too old.
Yeah. No, so anyway, but Toby Watson did one in Wisconsin. So it was Watson, Watson, X-Rail, United States versus Dr. King Vassal. And the X-Rail stands for relator, so the plaintiff is technically the government, and you're the relator, suing on behalf of the government, which means you're suing on behalf of the king of the government, but it comes from medieval, you need to know that. Okay, so under the False Claims Act, it's a false claim to knowingly present or cause to be presented a false or fraudulent claim for payment or approval to the federal government. Okay? And knowingly is defined as actual knowledge, deliberate ignorance of the truth or falsity, or reckless disregard of the truth or falsity. And you don't have to prove that there was any intent to defraud. Okay? So, and one of the principles of government contracting is if you're contracting with the government, you are supposed to know the rules. And you don't really get to rely on the government officials saying it's okay if it's not. Okay? And each false claim carries a minimum penalty of $5,500. So in each prescription is a false claim. You have caused a false claim. You've caused a presentment or submission of a false claim. So any prescriber worth his or her salt would have done 1,000 of these, right, in the 6-year statute of limitations, right? Well, that's $5.5 million. And so our idea on this is to tag, one or more of these psychiatrists or other prescribers for this, hopefully bankrupt them. And I feel no sympathy for these prescribers. And that will scare the shit out of the other doctors. That is the theory. Okay? And, okay, so if the government intervenes and takes over the case, the relator receives 15 to 25%. If the government doesn't intervene, the relator receives 25 to 30%. Okay, so so here's the fraudulent scheme. The drug companies have basically lied to the prescribers that these drugs are safe and effective, right? And they induce the psychiatrist to prescribe the drug, and then the pharmacy, and that gets presented to the pharmacy, and then the pharmacy pays and puts the bill into Medicaid. And so this is at step 2, which we'll really address that, although also going after the pharmacies. We have a model complaint, I'll talk about it in a little bit. So the psychiatrist causes the false claim when they write the prescription. Okay. Now, there have been billion-dollar settlements at step 1 against a drug company, multi-billion-dollar settlements. Eli Lilly paid $1.4 billion. I didn't get any of it. I got a bunch of legal fees out of it against me. And what was it? Pfizer paid $2.4 billion. Johnson & Johnson paid $750 million. AstraZeneca. So they paid a lot of money for, specifically at this stage. And they've settled all these cases. But it doesn't mean squat, right? Because what is $1.4 billion to Eli Lilly for Zyprexa? When they did that, they were selling $5 billion a year. And not only, and so what that did is that put a cap on their liability for all of their past misdeeds. And they're still selling Zyprexa. The prescribers are they're still making money on it. The prescribers are still prescribing Zyprexa to children. Zyprexa probably isn't the worst, most common one for children. Maybe it's the Risperdal, I think, probably. But the same idea. And the government is continuing to pay the claims, right? And so these big settlements at step 1 have not been effective. And so that's why the idea is to go after the doctors and also potentially go after the pharmacies. And the reason to go after the pharmacies is the bigger ones have enough money to make it worthwhile to the lawyers. Now, Randy was willing to do it because he's a believer, for a believer. But most lawyers want to make a bunch of money, and a psychiatrist might have.
I would have been happy to make a bunch of money on that case, Jim. The defendants that we sued, and I still can't remember the relative's name, but it was a sole practitioner, psychiatrist, a mom and pop drugstore. We should have had an easy settlement, but I think the court.
Well, what happened in that case? Well, the government came in and said, well, these people don't have enough money to make it worthwhile, and so we want you to dismiss it. They moved to dismiss it.
Yeah.
And they have the government has virtually untrammeled discretion to dismiss. You're suing on behalf of the government, so the idea is the government.
But I remember you had never seen that.
No, that's the only one.
Yeah.
But there have only been 4 cases, so. Yeah, so at first they said, well, that Randy only alleged a half a dozen prescriptions. And then we said, well, yeah, but then you have to do that to get in the door, but then you do discovery and there'll be a bunch of prescriptions. And then they said, well, yeah, but there's not enough money for us to make it worth us not doing anything, right? Because if you don't, I don't think I really talked about this in here, but if the government has the right to intervene and take over the case, and then you get a smaller amount. But if they don't intervene and take over the case, you can just go ahead and prosecute it. And so they didn't really have to do anything, except
they just ignored it. Why they didn't, I have no idea.
Well, I don't know. So, but they consider their client to be the CMS, the Centers for Medicare and Medicaid Services, and they're not in favor of these lawsuits. So anyway,
Why would they not be in favor of these lawsuits?
Makes life complicated for them.
Because I think basically because they're going up against the medical establishment, and you know, the doctors say, you know, we need to be able to prescribe off-label or it's common and all that kind of stuff. But if you think about the reason for the restriction to medically accepted indications, okay, that's why you have the FDA, right? Okay, to find out if it's, you know, safe and effective. Of course, in the U.S., you can prescribe a drug for, once it's been approved for any use, you know, for a use, it can be prescribed for any use, okay? But if you prescribe it to a Medicaid patient, and it's not for medically accepted indication, you're causing a false claim. And people don't really, you know, it takes a while for people to kind of get that idea. Okay, so there are a number of procedural hurdles, and one that I got tripped up in Alaska on, which was my own damn fault, is the public disclosure bar. And it was amended in 2010. It used to be more restrictive. But the idea is if substantially the same allegations or transactions were publicly disclosed in a federal proceeding, criminal, civil, or administrative hearing, in which the government or its agent is a party. Now this just used to say any criminal, civil, or administrative hearing. And then it was decided that included state hearings and whether or not the government even knew about it. Or in a congressional, basically in a federal report. Again, they didn't have federal reports. And from the news media. So let's talk about 1 and 2. Before 2010, I mean, the courts kind of like to throw cases out because then they have less work to do. Okay, so they like to find reasons to throw cases out. And so they held that state actions barred, you know, barred these cases. And it used to be that this court didn't have jurisdiction. Now it says the court shall dismiss an action unless opposed by the government, which is also new. So, but in any event, so they kept restricting these cases. The courts did. And the idea of Congress, that's not the idea of Congress. The idea of Congress is to get people, you know, to sue on behalf of the government. And the government's made a lot of money. I mean, you read probably every couple of weeks or hear every couple of weeks about some False Claims Act whistleblower case. Okay. And then from the news media. And the idea is that these are supposed to be whistleblower cases. And if the government already knows about it, well, not that they know about it, because that used to be the, before 1986, that used to be the criteria if they knew about it. And then the defendants would, you know, dig through these humongous files and say, aha, see, here's something you knew about it. And so now it was that had to be publicly disclosed. Okay. So the idea is that once it's publicly disclosed, that will bring pressure on the government to bring these cases. Okay. And therefore you don't get to do a whistleblower. I could go more into the, you know, the things that happen on this. But this is something that you have to get over. And okay, So, and then one of the requirements is particularity. There's a civil rule that says if you sue for fraud, you have to, in your complaint, describe the fraud provide the particulars. So you have to be specific about what the fraud is. And so, but in this case, as I said before, there are only two things that you need: the diagnosis and the drug. And if it's not on the medically accepted indications chart, it's a false claim. Okay? And then once you do that, then you can conduct discovery. And in Toby Watson's case, I mean, I don't know how much I probably should move farther along here. But we had not very many prescriptions, about the same as Rainey's case, but we got to the discovery phase, and we found so many thousands of false claims that we just limited it to Geodon and Risperdal, and then yeah, basically that. And maybe ones after the Court of Appeals ruled that we were right. So anyway, you have to be the first to file. And one of the things, I don't think I really put this in there, these have to be filed in secret. Okay, you have to file them under seal. And the idea for that is that you, in order not to interfere with an ongoing criminal investigation by the government. So you don't want to let the idea is you don't want to let the defendant know, if the government is, already trying to investigate. It's supposed to only be 60 days. You're supposed to only, the government's supposed to only be able to extend it for a really good cause, and they're just extended all the time. The average time is 15 months, I think, or it was when I looked at it last time. And Zyprexa was 5 years before they finally got it out from under seal. And usually when they get them out from under seal, it's because the government has worked out a settlement with the defendant. Okay, you've got to be the first to file. If multiple people file about the same thing, you're technically not supposed to, the segment was not supposed to get any payment. But lots of times the relators work that out so that they don't have to get into an argument about, is it exactly the same case and that kind of thing. An attorney is required, so you can't do them pro se. And there's a 6-year statute of limitations. So that's that.
What, can I ask you a question?
Yeah.
About why an attorney is required?
Because there's this rule in the U.S. that if you're not a real person, like if you're a corporation, you have to have an attorney to go to court, and the government has to have an attorney to go to court. And since you're suing on behalf of the government, you have to have an attorney. Okay, so we developed this model complaint, and it's drafted for a former foster youth to sue the prescriber and actually the agency and the pharmacy. And we did it that way just because it just seems fair, for a former foster, you pretty much have to be a foster youth. But anybody with this knowledge could do it, like a parent whose child has been taken away, for example, a counselor, doctor who gets stuck with these cases, with these patients that, and I'm not sure that I really went into it that far, but I think I kind of stopped in the middle. But the idea for suing the pharmacies is the big ones have deep pockets. And so, I mentioned 1,000 prescriptions, 5.5 million bankrupt, and, the prescriber. But, a prescriber might have 1 million or few to get, right? And that's all you could get. And then the relator gets 25, a quarter of that, and then the lawyer, they seem to get 40% now, so a third, gets 40% of that. And so that gets to be not very exciting to a lawyer. But if you have, you know, a big pharmacy, I mean, you know, 1 million prescriptions by Walgreens is $5.5 billion. Yeah.
In a lot of these cases, wouldn't you be, I would imagine that the doctor is working for a community service agency,
Right.
or is the government, is working for the government themselves, so is it the federal government often suing a state agency?
Usually they're not state agencies. Usually they are nonprofits that get state grants, which is not in the same category. In the Ninth Circuit, they say you can actually sue state agencies, but most of the circuits, and that's California, it's the western, Hawaii, Alaska, Washington, Oregon, Idaho, I think. Okay. So that's why we sue the pharmacies, is to get the lawyers interested. Not that we've gotten any yet. Randy and Toby had a local. I want to talk about two cases, one of which is not Randy's. So I filed this case, PsychRights filed a case in Alaska where we had 30 plus defendants. I ignored Susan Steffen's really good advice not to sue that many defendants. I had too much fun. That's what I would say sometimes. Too much fun. I mean, there were, 30 lawyers on the other side of the table, and I didn't really feel at a disadvantage that way. But we really I ended up causing a big problem for myself with the public disclosure bar, because the Ninth Circuit said, well, this looks like everybody's doing it, and the government knows all about it and doesn't care, so why should we? I mean, that's basically what they said. But it's specifically not precedent. It's called a memorandum of decision, and so they specifically said it's not precedent. And I mentioned before, that knowledge of the false claim isn't enough. It's got to be publicly disclosed. So they got that one, but I blew it in an oral argument. Anyway, so that's what happened in the Ninth Circuit. Well, the Seventh Circuit, which is Illinois, Indiana, and Wisconsin. Oh, that's where I was, Wisconsin. There's a Seventh Circuit case and another that says, in order to trigger the public disclosure bar, you've actually got to identify that public disclosure has to identify the person who caused the false claim, or submitted the false claim. In that case, it was, I think, what do they call it, upbilling for chiropractors, where they bill for a more expensive service than what they charged. And 50% of the chiropractors were doing it. They said that's not enough to trigger the public disclosure bar. So that's very good precedent for us. And we won on that issue in the trial court, but the trial court then said, well, you have to have an expert witness to testify that when a doctor prescribes for a Medicaid patient, that Medicaid is going to pay for the prescription. I go, what? I mean, come on. But they also said you have to have an expert witness to testify as to whether it's a medically accepted indication. And that sounds more reasonable, right? But we said, look at it, it's what's the diagnosis, what's the drug? And it's either medically accepted indication or not. You don't need an expert witness on that.
It's an issue of law.
Yeah. With those two facts, then you decided. Now there might be other issues like what constitutes support. So we won that, and then it got remanded, and then we got all this discovery. I mean, the judge, it came down like at the end of August, and the judge set the trial date for early December, and it was like, And I got in the case in the trial court after the remand, and so that was a really fast time frame. And anyway, the judge figured out what was going on, and he was very antagonistic and threatened Toby with very substantial sanctions or attorney's fees award against him if he continued. And Toby has children and stuff, and he decided he wouldn't do that. So that case went, the trial case went away. But we have really good precedent in the Seventh Circuit. I mean, they said, no, you don't need an expert witness to testify that when you prescribe a drug to a Medicaid patient, that Medicaid's going to pay for it, unless there's some reason to think that they're not going to pay for it. And they said, yeah, well, in some cases you might need an expert witness on medically accepted indication, but not in in these circumstances. So anyway, so it's terrific precedent. So there are some questions still to be litigated. One of the things that we do is there's so many situations, so much of the prescription is so clearly not for medically accepted indication, we don't even need to worry about some of the ones that you might have to litigate, like whether the 2B, it's some but not most cases should be used. We don't even sue about the 2B ones because there's so much else. Now, I found one, I forget what drug it was, but there was a positive report of 3 mentally deficient children receiving Depakote, and that got a 2B rating, and so that seems pretty amazing to me. But someone yesterday said something about polypharmacy not being medically accepted or something. But I mean, basically, I think that virtually all polypharmacy are false claims. Okay, now you saw that one where Abilify with Depakote is approved by the FDA, but that's the rarity. Okay, but we're not even going to go there. And then maybe the big one is, can the prescribers be charged with knowledge? There is this principle that when you're dealing with the government, you are supposed to know the rules. They don't really like, and that's this Heckler case. But in the Watson case, we had different time frames. So we had when the complaint was filed, and we got all this discovery after from after the complaint was filed. So we said, well, she should certainly have known once we filed the complaint and said it was wrong, right? Okay. And then the judge said it was not. These were false claims. We said, well, she should be charged. She knew about it after that, right? And then we even found, I forget, a few hundred in between the end of August and the 1st of October when we got our discovery. That was after the 7th Circuit. And the doctor testified at her deposition that she didn't read the 7th Circuit decision. So we say that she certainly should have had knowledge after the 7th Circuit. And the judge said, well, don't go waving that 7th Circuit opinion down here. So it was a very antagonistic vote. Okay, so that's that. So the third one, and that's the most detailed one, that's the one that the Medicaid fraud one is the one that we put quite a bit of effort into. I think that it really, it's like getting Al Capone for tax evasion. That it has the potential for really impacting the practice because, as those of you who were here for Roland before, a lot of this is about money, and if you start bankrupting psychiatrists, they'll sit up and take notice. Okay. But another idea we have is just to go after the FDA pediatric approvals, and you can probably do that for other, adult approvals too. To be approved, they're supposed to be safe and effective. And then the secretary or whoever, the administrator of the FDA, can withdraw the approval if the post-approval data shows that the drug is unsafe for approved uses, if new evidence shows lack of substantial evidence that the drug will have the effect it purports to have under the approved application, if the application contains any untrue statement of a material fact. Well, I think that's probably true of most approvals since, the beginning of, of time. But, and there is a process called a citizen's petition where an interested person can just petition the FDA, to take some kind of action, including revoke an approval. But you have, so this is an administrative proceeding. So you go to the FDA, you file a petition, they'll deny it. They'll rule against you. You just have to assume that. And then there'll be a process for internal appeal. And then you have to appeal to the federal court. So you have to figure that that's the way it's going to go. And that's kind of where I got a card. All right, well, I'm out of time. Thank you all for coming.